If you're saying lifestyle of the rich and famous, and you got Nathan Wade and Fani Willis, Fani making over $200,000 a year, and she going on trips, and all we talking about is a $4,500 vacation trip? We talking about Napa County in California, man. The way she stayed at the DoubleTree? Hold up. What about the Four Seasons? What about the Ritz-Carlton, man? What you mean the DoubleTree? I ain't gonna lie, the cookies good. You show up at the front desk, they gonna give you a warm chocolate chip cookie. I want my cookie now, but if I'm going to Napa County, the wine country, you know what I mean? What Ply say, man, we vibing at the Ritz-Carlton.
Call your first witness. I got Kenneth Willis. He bought his business, he gon' take it the distance. Listen, he giving gaming, believing high level represent. Call your first witness. Yeah, call your first witness.
Griff has been paid for this endorsement.
What's good, beautiful people? It's your boy K Will. Welcome to another episode of Call Your First Witness, man. I'm so happy to be here. Thank you for tuning in. I'm excited. Let me tell you something, man. Let me go ahead and just say this right now. I appreciate the love. I appreciate the support, man. I'm looking at my podcast numbers. I'm looking at the downloads. You know, I'm looking at the YouTube subscribers, the views, man. I don't know what happened, but I see the growth. I see the support. You know, the other day, early this week, I had about 15 subscribers. And I ain't gonna lie, I was appreciative of my 15 subscribers. And all of a sudden, I looked up, that thing that jumped from 15 to 95. Your boy had about 2.7 views. I'm like, man, what is going on? Y'all love that Fani Willis video. I ain't lying. Y'all love that video, man. So I'm going to keep it coming, man. I appreciate the support. I told myself when I started this, you know, if you heard me on my first episode, if you haven't, check me out. You know, I'm on all major podcast platforms. I'm on YouTube, Call Your First Witness. But my first episode, I said, look, I'm a fish out of water. This is all brand new to me. I'm learning as I go. I told myself, don't look at the scoreboard. You know, don't try to look and see how much engagement you're getting right now, man. Just keep being consistent. And that's what it is for me, man. It's about base hits. You dig? Base hits. I'm not trying to hit a grand slam. I'm not trying to hit a home run. I'm just trying to get on the base. You know, first base, second base. You know what I mean? Like, in the support that I'm getting, man, I appreciate it. And it's giving me that energy, that positive energy to keep going. So I just wanted to go ahead and give y'all a shout out. I see y'all. I appreciate it. Now, look, let's get into the show. Let's get into the show, man. I'm coming back with Fani Willis. I'm sorry. You dig? That's what's hot right now. I got this podcast. We covering a lot. You know, I said it from day one. We going to hit you with Know Your Rights. We're going to put some of our up-and-coming lawyers on game, our aspiring attorneys, put them on game, show you the tricks of the trade. You know what I mean? But we covering what's in the news. And I've always said it, man, it's been on and popping in the ATL. I'm covering the RICO trial, Young Thug. I'm covering that case. Check me out on the first 2 episodes, 1 and 2. I'm coming back to that. Believe that. I'm coming back. But I'm kind of chilling right here with the Fani Willis case. Got a lot going on. Something popped off. You had a hearing, a Senate committee hearing. I was like, what's that all about? So we had that going on. I'm going to jump into that. But I want to pick up where I left off at. All right. Where I left off at, we were kind of talking about that Friday. Remember, Friday, March 1st, that was a big day. Right? Because we really didn't know if the judge was going to make a decision that then and there. My forecast was like, because of the new developments, I'd be shocked if the judge was going to be ready to make a decision on that date. But what we did see, and maybe you didn't see it, so I'm gonna fill you in. It was closing arguments. Now remember, this is not a trial. This is an evidentiary hearing, right? And so the allegations are Based on the defense lawyers, Trump and his co-defendants, the allegations are Fani Willis and Nathan Wade committed a conflict of interest such that they should be disqualified from this case. And even a step further, Ms. Merchant, the attorney that represents one of the co-defendants, is saying, look, not only disqualify Fani Willis and her entire office, but the whole case need to be dismissed. So that's what got us there, and it's an evidentiary hearing. And what's interesting about this situation is the burden shift. In any criminal case, the state has the burden to prove the defendant is guilty beyond a reasonable doubt. You've heard that, right? You've heard it. You've read about it. You know this. And that burden is a very high burden. But leading up to that, we have not gotten into the actual trial. No jury, no witnesses, nothing like that. However, we got the defense lawyers filing what we call preliminary motions. And this is a big motion where they're saying, listen, based on what we got going on in this case involving Fani Willis and Nathan Wade, they need to get off the case. It need to be dismissed. And so the burden shifts to them, right? Because they have to prove the conflict of interest. They have to prove that Fani Willis and Nathan Wade have enriched themselves. They cannot be just. They cannot exercise their judgment because it's clouded because they're trying to make money. They doing this all for the bread, basically, right? But the burden shift, it's like, okay, defendants, if you say this, you must prove this. It's nothing different than as the state has the burden. If the state's going to claim that Trump and the other co-defendants interfere with an election, they were trying to steal votes, you can't, saying it so don't make it so. You have to prove it beyond a reasonable doubt. But yes, defendant, in that same vein, if you're going to say there's a conflict of interest, all this going on, them taking all this money only for the purpose of pursuing this case and making more money, and Fani Willis is going out in public and condemning Trump and the co-defendant's guilt, talking about their guilt. If you saying this, prove it. And not only are the defendants saying this, they're also saying, man, y'all committed perjury when y'all took the stand. Fani Willis, Nathan Wade, when y'all took the stand, y'all committed perjury. That's a criminal offense. That's grounds for an ethical violation. That in and of itself, we got lawyers saying that action in and of itself is grounds to disqualify Fani Willis and Nathan Wade from the case. So you got a lot going on, but the burden is on them. And what's interesting about this burden is we haven't even really established what does that burden mean, right? If you think about the burden, I talked about it. The burden in all criminal cases proved beyond a reasonable doubt. But now it's a different type of burden. The defense, they're saying the burden that we have to establish that Fani Willis and Nathan Wade committed these actions is by a preponderance of the evidence. Now, if you haven't heard of that before, most of the time you hear that when we talking about civil cases, maybe automobile accidents, that sort of thing. What does a preponderance of evidence mean? Basically what it means is, listen, if you can prove just 50% plus 1/10, right? A nudge slightly over 50%, you can prove that burden. If we look at it mathematically, you win your case, right? So the defendant's saying a preponderance of the evidence. However, you got the state saying that's not the burden. And so what the state is saying, no. It's not a preponderance of the evidence. It's a higher standard. Now, the state did not articulate what the standard is, but they say, listen, it's a high burden. And we know it's a high burden because if you look at the jurisprudence, these cases say, listen, man, if we talking about disqualifying a DA, someone that the public, the general public voted into office, man, that's like the option of last resort. Like we want to be really reluctant to do that, but certainly if the law and the facts show that it has to occur, then they're going to have to be disqualified. So right there, you already have, I mean, this is from out the gate, polarizing positions, preponderance of the evidence, a higher standard. Now, why is that important? whenever you are arguing these cases, right? We're talking about closing arguments. So all we're saying is, look, everything you establish with facts by way of evidence, testimony, everything you establish, not argue it. Argue it to the judge. Wrap this thing all up and put a bow on it in front of the judge. And a lot of times the judge, closing arguments are critical to the case because a lot of times the judge still got some unanswered questions. Sometimes in these type of cases, I'm not even going to say in these type of cases, but sometimes when you have a hearing with a judge making a decision and there's not the jury involved, sometimes you have the judge, after listening to the evidence, they already know what they're going to do, right? Because they listen to all the evidence. They know what the law is. They probably need more time to research certain things, but they already kind of lean in a certain way. But a lot of times, you know, that closing argument is pivotal because something you say or in response to the questions that the judge asks, you could make that person change their mind, right? They could be leaning one way and you keep presenting your argument, that judge turn around there and lean the other way. And the reason why I know this is obviously from experience, but man, I could go all the way back to the fundamentals, all the way back to law school. Man, I have a final exam, whether it's a final exam, the bar exam, and what we need to do is read the hypothetical and find what we have to do what we call issue spotting, right? So based on the hypothetical, you got a whole lot going on in this fact pattern. And then the call of the question is, based on the facts, do you believe that Johnny should be found guilty for murder, right? And when you look at the fact pattern, you may have an answer in your head. And a lot of times you got to outline what the answer is, what the analysis is, what the law. And as you're writing it, you realize the initial answer you had changed, right? So because you're doing this step-by-step analysis, you didn't change your mind. So if that's happening on a law school exam or on your bar exam, believe it or not, that can happen in real life. Judges could be leaning a certain way, having this intellectual exercise between themselves and experienced lawyers, and something you're saying and the position you're taking and the law that you're citing may sway a judge in a different direction. So last Friday was a big day, and what I was paying close attention to is the judge's questions, right? You can always discern the wisdom of someone based on the questions they ask, right? And so the judge is asking both sides very pointed questions, and it's not one-sided. I saw the other day one of the reporters, I'm not going to say their name, I'm not going to say the network, but they were like, yeah, the judge got a lot of questions for the defense, and they ain't really asked a whole lot of questions for the state. That wasn't true. The judge had specific questions for the defense and the state. It felt like it was 50-50. So I personally couldn't call it. Like at this very moment, I can't call it heads or tails how the judge gonna rule. And that's what fair judges do, man. They not gonna show their hand. They not gonna show you how they leaning. They gonna call it right in the middle. They gonna have specific questions for the defense, specific questions for the state. You like, man, I can't read them. You know, Judge McAfee like, man, what we talking about personal interest? What we talk? Let's get right into it, right? And so the first lawyer that stood up for the defense was Mr. Merchant, all right? That last name sound familiar. Merchant, we saw more from Ashley Merchant. Mr. Merchant is Ashley Merchant's husband. They both represent the same client, a co-defendant of Trump. And so Judge McAfee is like, listen, tell me about personal interest. Y'all, the first thing that pretty much, I'm not going to say the first thing that came out of his mind, but out the gate, he said, man, it's like obscenity. You know it when you see it. Now, y'all, let me tell you something, man. That statement, it's like obscenity. You know it when you see it. That's pulled out of a landmark case from 1964, a landmark United States Supreme Court case, when the issue at stake was whether or not a motion picture was considered hardcore pornography, right? And Justice Stewart said, listen, based on this motion picture, I'm not going to say this is hardcore pornography. This is not what it is. I can't articulate what it is, but it's not that. You know it when you see it, right? And this is a very profound statement, probably one of the most popular statements that came from the Supreme Court as long as the court has existed, right? But the problem with that is like, hold up, man, how you gonna cite that? Because even till this day, there are detractors saying, yeah, that's a very profound statement, very popular, pulled out of 1964 Supreme Court opinion, but it's very arbitrary. It's very subjective. So if out the gate, Mr. Merchant, your best argument is it's like obscenity, you know it when you see it, essentially what you're saying is, man, you can't even articulate whether or not there's a conflict of interest. After all these days, bruh, all this testimony, witnesses after witnesses, documents, motions, you know, the first thing you can say is, you know it when you see it? Come on, bruh, you probably should have said that for last. That should have been like argument number 5, right? Not argument number 1. You know, and the beautiful thing about that's why I like co-defendant cases, right? Where these conflict cases where you got multiple defendants, because what happens is most of the time, all the defendants have an inherent conflict of interest, right? And so the lawyer can't represent 2, 3, 4 defendants, right? Because you never know in that given situation, if the lawyer find themselves having to defend one client, but throw another client under the bus, that's what we call divided loyalty, right? And so that's why everybody got their own lawyer. But what's interesting and what's beautiful actually about when you have multiple lawyers is you have multiple legal minds working in concert, right? And so the approach is a lot of times we like, look, we understand we can't be stepping on each other's toes. We got to represent our own client. But some of this stuff, we could kind of have a united front, right? And so the united front is what we trying to accomplish here. We trying to get this case dismissed. Bet. Let's do it, right? The united front is we all need to be arguing that Fani Willis needs to be disqualified. Hence, the whole DA's office needs to be disqualified. So we got to all be on the same page, make sure we not stepping on one another's toes, but let's make this work together. So what happens is at this closing argument, you got an allotted amount of time where each lawyer are arguing certain issues, right? You're not smart if everybody getting up there arguing the exact same thing. You just wasting time. That's why you got one lawyer say, look, I'm going to argue this. You get up and argue that. That's where we thorough. You know, it's like a remix song, right? You got the original version and then you got the remix. So the primary lawyer, Miss Merchant, who filed these motions, that's the original song, right? But the next lawyers, the other co-defendants, they get up, same song, right? Same hook, but different spin to it, right? So I'm gonna give you the same song, same hook, but I got my own little spin, my own little spice to it. So I'm arguing something more to the judge. And when we all done, after this, I don't know, hour and a half long worth of argument, we done touched on so many issues, right? That gives the judge so much to chew on. That's just strategic lawyering, man. If the overall objective is getting this case dismissed and getting Fani Willis disqualified, that's how we got to roll. That's why you see lawyers having different arguments, focusing on different issues. And so the first lawyer, he said, you know it when you see it. That tell me, bro, you ain't proving what you need to prove, right? And so the Judge McAfee is like, listen, what standard we talking about? Are we talking about actual conflict of interest? Are we talking about appearance of a conflict of interest? Y'all, that is major. When I say that's major, that's pivotal to the case. I mean, the whole case can turn on whether or not the facts are going to turn on whether we have to look to actual conflict of interest or the appearance of conflict of interest. Let me tell y'all something. There's a significant difference between those two things, right? You got judges, I at least know in Louisiana, you got judges say, listen, I'm getting off the case even if there's an appearance of a conflict of interest, right? If I'm presiding over the case, there may not be a conflict, I don't even really remember who this defendant is or this prosecutor who worked on the case. But in the public's eyes, I don't want folks to think I'm not being fair. So I'm going to just go ahead and get off the case, right? That's just the appearance. But when we're talking about actual, listen, forget appearance. We need to look and see whether or not there is an actual conflict of interest. And so there is a significant discrepancy between those two things, because certainly, and of course, the defense is saying it got to be appearance. The state, polarizing position, no, it has to be actual, right? Because that's more that the defense has to prove. If we saying just the appearance, the defense like, listen, man, we got a relationship that's been acknowledged. We got an exchange of money that's been acknowledged. Judge McAfee even said, listen, we could get past that part. That's been acknowledged that there is a relationship. It's been acknowledged that money exchanged hands, right? We don't need to speculate about that. That's not conjecture. That's been proven. So if we have that, then we could take that and say, man, that is an appearance of a conflict of interest, right? What y'all doing with this money? Why is he on the case? Why is Nathan Wade on the case? Of all special prosecutors, you got Nathan Wade, the guy you sleeping with? You could have got some other special prosecutor. What's the deal? Y'all going on trips? It smelled too bad, right? The public can't trust this because it just look a little shady. You know what I mean? Well, no, it's not just the appearance. The state is saying it has to be an actual conflict. Judge McAfee is asking this question, and he's saying, listen, there's some ambiguity between this in the case law. It's unclear what standard we need to apply. And he's asking both lawyers. He's asking the defense lawyers. He's asking the lawyer for the state. What do we apply? And of course, they got polarizing opinions on that issue, right? And so the judge is asking about that. We can't really get a clear answer. And the second lawyer gets up. Again, it's a remix, so he focusing on something else than what Mr. Merchant was focusing on, right? And so he get up and they say, listen, I just want to focus on forensic misconduct. What is forensic misconduct? We've heard that term. You may have heard it. You may not have heard it. But basically, the defense saying it's a subset of the conflict of interest, right? And essentially, they're saying if the prosecutor is making public statements condemning the guilt and the innocence of the defendants, then they need to get off the case because that's impermissible. That runs afoul of the rules of ethics. Prosecutors can't do that. And what they're saying is this is what Fani Willis was doing. And so they're pointing to a speech, a church speech. They saying Fani Willis was condemning the defendants. They're not really saying it, though. They just saying she was deflecting the allegations asserted in the defense's motion to disqualify her. So the judge flat out was like, listen, man, do y'all have any statements from this speech that she condemned the defendants? They couldn't point to it. All they could say is, man, she was deflecting. Then they brought up the book. There's this book called Find Me the Votes. And Fani Willis was interviewed in this book. Judge McAfee was like, listen, does she got any statements condemning the guilt or innocence of the defendants in this case? These are the questions he's asking, y'all. They don't have a response. They was like, we don't have that, but let me tell you what we have. Again, you falling short of the standard. What do we have? The judge keeps reminding the defendants, it's y'all burden. And it becomes very interesting because they kind of venture off into the credibility of the witnesses. Y'all, this is key, right? The whole case can turn on the credibility of the witnesses. And this talk about the timeline. I keep talking about the timeline. In my previous video, I talked about the importance of the timeline. The defense are saying, listen, this relationship between Fani Willis and Nathan Wade goes back to 2019. Fani Willis and Nathan Wade are acknowledging this relationship, at least the romantic aspect of it, started way after he was employed by Fulton County, right? He was employed November 1st, 2021. Fani Willis, like the relationship started March of 2022, the romantic relationship. And so that's important because now it's like, hold up, y'all were plotting long before this. Y'all were in a relationship long before this. And so what the defense did was like, listen, we got a witness that contradicts what Fani Willis and Nathan Wade asserted, right? We got a witness. That witness's name is Terrence Bradley. Y'all probably heard of him. Terrence Bradley was the guy who used to be the partner at Nathan Wade's firm. Y'all, can I park it here right quick? Not even right quick. Let me take my time with this, y'all, because the last video I was trying to squeeze it in. I didn't get a chance to. I was like, man, it's a lot. I was trying to cover a lot of material in a short amount of time, so I just left it out. Can I come back to Terrence Bradley? Because I just got one question for you, big dog. I promise, just one fundamental question for you. Bruh, what were you thinking? Bro, what were you thinking? Hold up, y'all. Wait a second, man. You mean to tell me, like, because I was confused. Y'all, I was confused because one day, man, I'm at home, quick lunch break, you dig? You know, my office not too far from my house, so I go home, eat, cut on the TV. I'm following this case. What's going on? I think this was maybe last week or the week before. I'm losing my track of time, man. Things moving so fast. But I see Terrence Bradley on the stand, right? And Miss Merchant is cross-examining him. And she like, yo, she is referencing text messages. Miss Merchant and Nathan Wade, they're communicating via text. And they comfortable. You dig? I remember Miss Merchant was like, in the text message, she was like, is Nathan that stupid? What he doing with the money? He that dumb? That's what she's texting Terrence Bradley. So that's telling me, ooh, they comfortable. Like they just speaking freely. Like they must have been exchanging for a while. Turns out they were texting for months. But I'm looking at Terrence Bradley. He on the witness stand with that look on his face like, what we doing right now? Why you asking? He very abrasive. He's very evasive in his responses. He's asserting attorney-client privilege, and no, I can't answer that question, and I don't know what you're talking about, and you're gonna have to be more specific. Hold up, dog. You ain't do all that in the text messages. You were very comfortable in your text messages. Now all of a sudden you understand a certain attorney-client privilege. Hold up, cuz. It's too late for that. It's too late for that. You should have thought about that before you started sending those text messages, man. What were you thinking? And then I found out, wait, because this don't make any sense. You got on one hand, they chilling, keying in the text message in the thread, and then now you're on the witness stand like you don't know nobody. You acting brand new on this witness stand. Miss Merchant grilling you, though. She pulling the text messages. She impeaching you, big dog. But I'm trying to figure out what then went wrong. What happened? Turns out, dude used to be Nathan Wade's lawyer. Not only was he his partner at the firm, he was his family law attorney. Hold up. You mean to tell me now you on the witness stand asserting attorney-client privilege because Nathan Wade was your client. I don't care if he's your existing client or he your former client. You asserting attorney-client privilege. Any information you got as a result of that relationship cannot be divulged, right? But you ain't assert that when you were sending them text messages. And then we found out that you and Miss Merchant were in a conference room at a courthouse and y'all were keying in the conference room and you were laying it out for her. You ain't assert attorney-client privilege then? It's too late for that, big dog. What you doing? I thought you was this man lawyer. Hold up. What type of lawyer are you, bro? This dude is on national TV. You mean to tell me you this man lawyer? And look, I don't know what happened in the past. I heard about some allegations he was involved with somebody, I think from the office or maybe a client. I don't know. I didn't get too deep into that. But I realized that he had to go his separate way, right? And so clearly Nathan Wade, and it was like Nathan Wade sided with the alleged person that was assaulted and said, he was like, dog, Nathan Wade was like, Terrence, bro, you got to go, bro. This bad business right here. What you doing? You know? And so from what I'm gathering is Terrence Bradley, you know, Terrence was salty about that. And I get it, man. It's bad blood. Nah, it's like, hold up, man. You done sided with her. We don't know what's true, what's fact, but he upset. He like, dog, we don't rock like that together. You mean to tell me after all this time I'm out the firm? I'm out? I didn't put my blood, sweat, and tears into this firm, and I'm out? So you know there's strife between Wade and Bradley. You know that exists. And you know Bradley and his feelings. So now it's like, oh, okay. You want to bring me down? Nah, cuz you going down. And so now you running your head, cuz. Terrence Bradley running his head. But see, the problem with Terrence Bradley running his head, dude, you got to be careful who you run your head with. First of all, you shouldn't be talking, period. End of the story. You shouldn't be talking, dog. Keep your mouth closed for so many reasons. All right? Starting with, that was your former client, man. The rules of ethics say, man, you can't be divulging that information. Man, what you doing? My wife is an attorney. She would never know about, we have mutual friends, man. There's certain things she will never know about our mutual friends because it's protected under attorney-client privilege, right? We could be talking, and then all of a sudden, I'm like, I don't know about that. She's like, bet. She would never know. That's just the nature of what we do. You can't, and the reason why I'm saying that is because that's my wife, but she'll never know. We could be pillow talking, all that stuff. Man, when you talking about attorney-client privilege in the trust, that's a type of relationship that cannot be broken. That requires trust, man. So now you on national TV telling the world, oh, it's cool. I don't got a problem with telling folks about my client, and you getting into details about, oh, I wouldn't have never did that to my wife, and he wasn't paying his wife, and I take care of my business. Dog, what are you doing? And it ain't just that. It's like, hold up, man. You got to be careful. You done already committed the ultimate sin, right? But then now you willy-nilly telling that to anybody. You got to exercise your judgment since you want to run your mouth. And I know you in your feelings. I get it, bruh. I'm not even going to get into all that. You got every right to feel the way you feel. I'm just saying you need to be careful who you divulge certain information. Sometimes you telling folks information that may bring you down. And I'm trying to figure out how in the world, dog, you a whole lawyer. Did you not think that if you share this information with Miss Merchant, that thing could turn around and backfire on you? Bruh, Miss Merchant is operating, she's loyal to her client. You may not be loyal to your client, Nathan Wade, but Miss Merchant is trying to get information. She not trying to be your friend, bruh. You know, I get it. Y'all trying to use one another. She want information from you. You trying to bring them down, so you going to share information, but you forgot to think about yourself. Hold up. How it look if this information come out, folks going to start asking questions. Where did the information come from? Miss Merchant ain't pull it out of thin air. Who's your source? And Miss Merchant, she was like, I was trying to protect them. I felt bad for them, but I had to disclose the information because the state needed the witness. So that's why the information came out. Man, Miss Merchant don't care about you, bruh. She worrying about her client, which she should be. You just a casualty of war. You are a casualty of war, bruh. It's like in high school, you know. Every now and then we had that girl kikiing, laughing at our jokes. Do you really like me? Or are you just trying to get answers to this test? Right? Come on, man. Do you really, are you just kind of laughing and smiling? Or you just, you know, you trying to play me. You trying to play me, you dig? I need a date for the prom. You dig? You tell me, man, look, I don't know if I'm going. You show up to the prom with the starting quarterback. I got that D look on my face. But you were laughing at my jokes. She like, Mr. Bradley, like, how you could do this to me, man? How you, Miss Merchant, like, And I'm trying to figure out, how did Mr. Bradley not think of that? And it's like, man, hold up. You sending text messages. You ain't think, man, maybe I may end up in the middle of all this. It's going to come out. The whole time you was like, man, don't disclose my information. I'm just giving you this to bring them down. You look up, you on the witness stand, a certain attorney-client privilege. You got your lawyer in the jury box. He jumping up like Jack in the Box to try to protect you. It's too late for all that, big dog. It's too late. But anyway, so the defense lawyers, they saying, look, man, he is showing that Nathan Wade is lying because he's telling us about the relationship. He's telling it the relationship goes way before November 1st, 2021. They were messing around. They met each other at a CLE, a continuing legal education, long before that. Nathan Wade was the teacher of the class. She attended the class. That's how they met, and they've been kicking it ever since. How you know that, though? So judge was like, look, listen, aside for that, let's say he established that, right? What is that proving? What is that proving? All you really have is him giving a statement, not even on the stand, because he didn't say that on the stand. They pulled up a text message. You don't know if his information is from gossip. You don't know if it's attorney-client privilege. You don't know if it actually happened. You really don't know. They didn't call Nathan Wade back to the stand to address this. So all you really have is two conflicting testimonies. You got Nathan Wade's testimony. You got Terrence Bradley's testimony. The judge has to discern what's the truth. The judge could say, he could throw everything out and say, let's look at some more of this evidence and see where it fall at. So the state saying, man, you really don't got nothing. The defense hanging their head on Bradley. They need him. Look at the text messages. Look at the text messages. So it's a lot of back and forth, y'all. And the judge has interesting questions. And then he starts asking about, all right, how much money we talking about? At what point do we consider the money, right? The amount of money that exchanged hands. We understand it was established that money exchanged hands. There's a ledger somewhere around $17,000 to $20,000, give or take. We get that. But the judge is like, man, do we look into the amount? And I believe the reason why he's asking the amount is because if we look closely at the money that was spent, let's think about this, y'all. They asserted 6 vacations or 6 trips. And you mean to tell me out of all those 6 trips, we looking at under $20,000? That's all we talking about? And you got one defense lawyer who get up there and talk about this lifestyle of the rich and famous. Hold up. This ain't lifestyle of the rich and famous. That's not what this is right now. I ain't gonna lie. If this whole story was to go to American Greed, that's my show, American Greed. Stacey Keith to be like, hold up, y'all. I like this story for the salaciousness of it. I like it because we got Trump involved. We got Fani Willis. But y'all gonna have to bring back more money than $20K. You know what we bought? We bought that narrative, lifestyle of the rich and famous, and you mean to tell me they didn't went on 6 trips and it's only $20K? Man, he'd be like, man, tell Miss Merchant go dig deeper because we ain't talking about a whole lot of money. We're not getting on American Greed with this story. You got to give us more money. It's not a lot of money. In the state, they're making that point like, hold up, let's break these trips down. If you're saying lifestyle of the rich and famous, and you got Nathan Wade and Fani Willis, Fani making over $200,000 a year, and she going on trips, and all we talking about is a $4,500 vacation trip? That's what we talking about? We talking about Napa County in California, man, the wine country. What you talking, where she stayed at, the DoubleTree? What you talking about, the DoubleTree, man? You mean to tell me she got all this money and they gonna spend it at the DoubleTree? You dig? That's what the state's saying, man. Hold up. What about the Four Seasons? You know what I mean? What about the Ritz-Carlton, man? What you mean the DoubleTree? I ain't gonna lie, the cookies good. You know what I mean? You show up at the front desk, they gonna give you a warm chocolate chip cookie. They gonna give you that. I want my cookie now, but if I'm going to Napa County, the wine country, you know what I mean? What Plies say, man, we vibing at the Ritz-Carlton. You dig? Pull up at the Ritz-Carlton. No, bro, what you talking about? DoubleTree. Man, that's so crazy. Man, that remind me of a fellas trip I was on many, many years ago, man, with the fellas, man. We kicking it. This year we in Miami. We were on a run, man. We used to go every year on trips. That particular year we were in Miami. And, man, it's the fellas, man. We hanging out. We chilling. South Beach. We just came from the ocean, man. Feeling good, beautiful day. You know how it is in Miami. Good vibes. It's around lunchtime. It's time to get something to eat. You dig? And so we like, ooh, it's time to get something to eat. Bet. So we kind of like just like trying to figure out where we're going to get something to eat. And one of our boys, I'm not going to say his name because that's my dog, so I ain't going to out him like that. But my boy said Subway. Bro, we all looked at that dude and was like, Subway? Bro, what this South Beach? What you talking about, Subway, dog? Like, hold up, man. This South Beach. This, bro, Ocean Drive. What you talking about? We trying to pull up at the Clevelander. What you talking about, Subway, dog? man, DoubleTree? Bruh, man, we vibing at the Ritz-Carlton, dog. I'm sorry, bruh. So basically, the state saying, man, this ain't a whole lot of money, and I think the judge agrees with that. What do you mean, lifestyle of the rich and famous? And so now they saying, well, look, defense like, look, man, we can't account for everything. That's all that was documented, right? But Fani Willis said money exchange, and so she paying them back $2,500 here, $4,000 here, cash. What's wrong with cash? Because you got to remember, her dad corroborated her statement, said, listen, man, I raised my child. Look, a man is not a plan. You dig? So you always got to have cash. So that's how she was raised. And a lot of women relate to that. Hold up. So he corroborated that, and the state also mentioned the affidavit from the guy from the winery. Remember him? He got on CNN. He was like, look, man, Fani Willis walked in there and paid for this cash. And she took care of me. That tip, she took care of me. So it's like, it corroborates. That's how Fani Willis roll, man. Straight cash, homie. What Randy Moss said, how you paying that fine, Randy Moss? Straight cash, homie. So now it becomes interesting because the defense is saying, well, look, we telling them they not proving, they don't got any proof of any deposits that Nathan Wade received from Fani Willis. The cash Fani Willis testified to, they never proved deposit slips. Wait. Hold up, defense. Hold up. And the judge said this. The judge said, well, where does the burden lie? Does it lie on the state or does it lie on the defense? Remember, I started off talking about the burden. It's no longer the state's burden to prove cash deposits. You allege, defense, that Fani Willis did all this. You have to prove it. We can't speculate. So when you say Fani Willis needs to present receipts and Nathan Wade needs to present deposit slips, you shifting the burden back to them. No, cuz you know how this work. You know how this work. You the defense lawyers. If we tried this case tomorrow, you'll be the first one telling the jury it's the state's burden. They came in here and accused my client of doing all this. They got to prove it, not us. Not my client. My client don't have to take the stand. My client don't have to present evidence. I don't have to do anything. As the lawyer, it's the state's burden. That's what you're going to be arguing till you blue in the face, and now all of a sudden you got the burden and you saying, oh, they ain't proved receipts. You got Miss Merchant at the hearing on this softball testimony, softball committee hearing, and she was like, well, look, yeah, because the phone records, they contradict what Nathan Wade said. If he innocent, Why don't he produce the phone records to show he wasn't at Fani Willis's house? What you talking about, Mr. Defense Lawyer? You know for a fact the burden is always on the state, and you on the stand talking about if I was innocent, I had my client present all the evidence to prove his innocence. That's what you saying? You better be careful with your statements. This live stream, you got another case, you in front of another jury. They were like, I remember you said if your client innocent, he need to prove it by showing receipts, showing evidence. That runs afoul of the Constitution. So these lawyers are hypocrites in their arguments. They need to prove, the state need to prove they're innocent. You would never say that. I ain't mad at you. I ain't mad at you, man. Look, I'm a defense lawyer too. I ain't mad at you. You got to do what you got to do. You understand? I get it, but man, don't get it confused out here. You know what the burden is? Half of y'all up there saying, man, I used to be a prosecutor. I used to be, I worked for the federal government as a prosecutor for many, many years and yada, 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 all self-righteous. This kind of behavior is not, one of the lawyers said, this is not prosecutorial conduct. This is not lawyer conduct. These people need to be disqualified. What you mean, these people? Hold up when you say that. What you trying to say? What's your subliminal? What's your undertone talking about? This not how prosecutors act. This not how lawyers act. Hold up. Because come with this same energy when the prosecutors are withholding exculpatory evidence. Meaning they're withholding evidence that points towards the defendant's innocent. Come with that same energy. This public hearing that they had when you got the committee, and look, listen, y'all, I'm not here for politics. I promise you, I'm a defense lawyer. I'm telling you my perspective as a defense lawyer. But come with that same energy, this Senate committee to investigate. Whoa, we having this committee to investigate what's going on, and we want to restore the confidence in the public to make sure this is not happening, and we want to maintain the guardrails of our public confidence in pursuing justice. What? Say what, bruh? What are you talking about, dude? You know good and well if the same allegations in the same county as it relates to Fani Willis and Nathan Wade, let's say Nathan Wade was the special prosecutor for the YSL Young Thug trial, and all these allegations were submitted, you know good and well you wouldn't have this special committee hearing. And you want to sanctimoniously call everybody and have this big old hearing, this big spectacle. When do you see that? I don't practice in Georgia. I don't live in Georgia. But hold up. Did you come with that same energy when prosecutors withheld evidence? Did you come with that same energy? I want to withhold the integrity and the public. We want to restore the confidence. You doing this now in the timing you doing it. What happened to separation of powers, big dog? You mean to tell me we simultaneously got this hearing going on in front of this judge and you want to have this big public spectacle and all you have is one witness? Yeah, we subpoenaed Miss Merchant to come and testify. I'm shifting gears, y'all. I'm sorry. I done went from the evidentiary closing hearing to the hearing that happened at the Senate committee, right? And you want to call Miss Merchant. Where your other witnesses at? You ain't subpoena any other witnesses? All you got is a defense lawyer who's coming in there. Everything that comes out of her mouth is for the protection of her client. And I ain't mad at her. And I think she's doing a good job. No lie. I'm going to give her props. She doing her thing. But where your other witnesses at? Because you can't subpoena the state. You going to subpoena Fulton County DA's office? What they going to say? You know what they going to say. How you going to subpoena me? We haven't even heard from the judge. What you doing? The timing, what happened to separation of powers, man? Chill on that. And look, then they got the nerve to say, look, we don't want over invade. We understand that there's a hearing, but we just want to probe into this to make sure. We need to see whether or not we need to change or amend the laws. Nah, we know what you're doing. We know what you're doing. Let's make this a public spectacle. Let's make this bigger than what it is. And all y'all doing is sending softball questions to Miss Merchant. Here y'all go. This is a softball game. Boom. Underhanded. Boom. Here you go. Boom. Ooh. Until Mr. Jones, it was Mr. Jones' turn. Yeah. Remember Mr. Jones? You got to have some checks and balances. You can't, you know what I mean? I'm not a politician. I don't spend a whole lot of time at the Capitol. But come on, you got to have somebody in there to say, oh, wait. You done spent 2.5 hours asking Miss Merchant softball questions, leading questions. She talking about everything. And her whole narrative is for the benefit of her client and Trump and everybody else. And you don't got another witness? One of the most essential witnesses will be somebody from the DA's office. You know you can't call them. So what you doing? So Mr. Jones come in and he got his questions. Because you remember, they started this thing 2.5 hours. Cabbage ball. Mr. Jones, all right, Mr. Jones, we're going to leave the floor to you. You know, you got about 10, 15 minutes. We're going to wrap up. Miss Merchant got things to do. Yada, yada, yada. Hold up. Don't rush him now. Come on, you took your time with this. Mr. Jones came out there. Miss Merchant, you know, she playing softball. Mr. Jones said, let's talk about this case. Let's talk about this Whitworth case. Tell me about this Whitworth case and how does this apply to your case? Miss Merchant like, ooh, she at the plate like, fastball, hard ball, baby. Wait, what you mean? Can you tell us about the Whitworth case? It's one of the first cases you cited in your motion. Miss Merchant said, I would have to look at the case. Wait. What do you mean you have to look at the case? It's one of the first. She said, well, that's not my first case. No, as it relates, Mr. Jones says, as it relates to this particular issue, right? This issue about a conflict of interest is your first state case, first state of Georgia case. Tell us about how did this case helps your facts. Ms. Merchant said, I would have to look at the facts of this case. You mean to tell me a case that she cited, she didn't know the facts? That's fundamental. We learned that in law school. You better know every case you cited in your brief like the back of your hand. But see, it was softball. Look, we're going to subpoena you. You come in here. Somebody going to come at you. They're going to cross you a little bit. You know what I mean? But you ready. You're a lawyer. You'll be ready for them. But look, we're going to lay it out for you. Mr. Jones hit a, let's talk about this case. All right? Let's talk about amusement sales case. Another fastball. She like, ooh, what about it? He said, man, that case was a contingency fee case. Yeah, we don't have a contingency fee case here, right? And they didn't find a conflict of interest. They didn't find a conflict of interest in the Whitworth case. How does this help you? You don't even know the facts of the case, right? Let's talk about this money. Let's talk about the lifestyle and the rich and famous. Let's talk, we talking about 20K? He said 1759, 20K. Let's round up. It's not a whole lot of money. This your case? So what do you mean by Fani gave Nathan Wade money? What do you mean by that? Did Nathan Wade not earn his money? Was he not prosecuting folks? Did he not send them to a grand jury proceedings? Did he not get an indictment? Did he not get folks charged? And this the part right here. He said, wait, didn't some of the defendants plead guilty? 3 defendants pled guilty. So you saying Nathan Wade, the same guy y'all allege is inexperienced, in over his head, but yet he got folks indicted. He done presented the evidence to a grand jury, got him indicted, and now you got defendants, at least 3 who pled guilty. So this so-called inexperienced guy we talking about, Nathan Wade, he got folks pleading guilty. As far as I'm concerned, the DA's office probably saying he's doing a good job. So it ain't that he was given this money, he earned his money. Yeah. Let's talk about these 3 people who pled guilty. 2 of them were lawyers. Ms. Merchant like, well, you know, They seniors, they up in age. They probably pled guilty just to get it over with. You know, I'd rather be chilling with my grandkids rather than fighting this. Lawyers pleading guilty to this kind of behavior? That's what they doing? Nah, man. Lawyers like, man, we about to fight this tooth and nail. I could play with my grandkids on the weekend. We gonna fight this. So how you gonna say there's no legitimacy to what this man is presenting when they pleading guilty? See, what softball was over with. See what happened, and Miss Merchant, I'm not saying, look, she could think on her feet. She doing her thing in the courtroom and in the committee, but all I'm saying, she showed up with just her softball gear. She left her hardball equipment in the car. You got to come with different bats because Jones got different questions, and that thing coming fast. Let's talk about this Whitworth case. Let's talk about why you got 3 defendants pleading. She wasn't ready for that one. Yeah, so it got tense, and before you look up, he out of town. The lead guy who opened it up, he like, all right, Mr. Jones, we gonna be wrapping this up. No, you forgot. Miss Merchant said she got time. She got time. You remember she got a matter in Fulton County later on that day. She got time. So let's not wrap this up because you done came with this one-sided situation, and I know how I go at the committee meetings. You got to present your point. You got to make your spectacle, all that kind of stuff. But I'm just saying, bring that same energy when other DAs are withholding evidence or committing prosecutorial misconduct. Bring that same energy talking about we want to restore the public confidence in the DA's office. Bring that same energy, big dog. That's all I'm saying. So, oh man, y'all, I this case is interesting. You know, it's interesting. It got a lot going on, man. And I told y'all I'm covering it. The judge, it's hard, y'all. It's hard to say because the questions, I could say the way he asked those questions, Judge McAfee, are back to the evidentiary hearing, y'all. Sometimes I just be running it. I told y'all I'm gonna just run it, but the judge asks pointed questions on both sides, and it led me to believe that he's really thinking. He's not quite sure. There's some things he wants answers from these lawyers, and he got the responses, and he said, "Listen, I'm gonna have something for y'all within 2 weeks." So we gonna hear something. It's gonna be hard. I told y'all in my first video, go listen to my previous video on Fani Willis. And I told y'all, I said, look, a lot of times it's not about the right answer, right? It's about the grader of the paper. It's about the decision maker. And so back to that standard, if we saying it only needs to be an appearance of a conflict of interest, then it's going to be hard for Fani Willis and our team. If we're saying it has to be an actual conflict of interest, it's going to be hard for Trump and the co-defendants, right? It's going to be hard, you know? And even if Judge McAfee, let's say Judge McAfee sides with Fani Willis, you're going to have some room. If we talking about an appearance and that's kind of still unclear based on the case law, man, that thing could get overturned. So I'm eager to see what's going to happen, y'all. Stay tuned. The judge, like I said, he going to have his ruling soon. So I expect to hear from him probably within a week. And, tune in, look for me, because I'm going to break the opinion down. That's what I plan on doing. Listen, y'all, I told y'all, man, we going to cover what's popping. That's what I'm doing, man. I feel the support. I appreciate the support. And one thing I'm going to do, y'all, I got to do my homework. You know what I mean? I got this all new to me, so I'm kind of looking and seeing what's going on, man. And I'm noticing a lot of narratives, like on social media and on TV, man, they just take it and run with it. And I ask myself, I'm like, are these people really listening to the whole testimony? Or are they listening to the whole hearing? Because, listen, I'm busy, but if I'm going to keep it real and if I'm going to lay it out for you, I got to know what I'm talking about. And I can't go with just sound bites. We got a lot of outlets, man. I think they're just taking sound bites and giving an analysis with the sound bite. I can't do that. It take me longer because I got to listen to all this material. This is what I'm here for. I'm committed. You know what I mean? So I'm putting in the work, y'all. I appreciate the time, man. I'm enjoying the feedback. Man, look me up. Those of y'all who just on YouTube, I have my podcast too. Look for me on all major directories. Those of y'all on podcasts, I got a YouTube channel too, man. Whatever floats your boat, you dig? I just appreciate the love. I appreciate spending time with y'all. Keep coming back. Share. Call your first witness, subscribe, tell everybody about me, like, all that good stuff. It's been real. I enjoyed my time. Talk to y'all later. One.
Call your first witness. I got Kenneth Willis. He bought his business, he gon' take it the distance. Listen, he giving gaming, believe in high level represent. Call your first witness. Yeah, call your first witness.
Griff has been paid for this endorsement.